Good evening, everyone. My name's Shannon Wilson and my fantastic co-host Keith Miles, and we are part of ICABA, International Career and Business Alliance. It is always our pleasure to bring information to you on a monthly basis regarding topics within the estate planning community. ICABA is a wonderful community based in Florida. However, they have nationwide access to the variety of topics that the members of ICABA have passion for and extra levels of expertise in. I encourage everyone on here to go on to icabaworld.com. That's ICABA world.com. Check out the website, entertain joining the organization, and then also they have several mastermind groups that you can gather more information on various topics, such as estate planning. There's a mastermind group on entrepreneurship. There's some on financial planning. There's one on faith that just it covers the gamut of information. So it's a fantastic organization. Again, I urge everyone to go onto icabaworld.com, check them out. Keith and I do these workshops every third Wednesday of the month for estate planning. We're part of the mastermind group on estate planning. We've covered topics such as estate planning as a whole. We talked about wills one month, powers of attorney, healthcare directives, trusts. And tonight we are going to go over special needs planning and what that looks like, especially in the estate planning arena. So if any of you have any questions as we go through the information, feel free to pop those in the chat window. We have a small group this evening, so either pop them in the chat window or unmute yourself and ask the question, or there's also a Q&A tab. I'm not sure if you all can see all of those, but feel free to ask your question. We also have reserved some time towards the end for specific questions and answer session. So without any further ado, let's talk about special needs and special needs planning and what that looks like. And I will have to caveat this by saying this is Keith's niche. So he is all over this. If you have any specific questions, feel free to ask. He is an incredible wealth of knowledge when it comes to special needs planning in the estate world arena. So special needs, what is special needs? What does it look like? How does it work? Why are we talking about it in this? And essentially, special needs planning is put in place for individuals who have certain disabilities in order to ensure that they still have financial access to assets that do not jeopardize or take away any rights that they may have when it comes to certain government benefits. Any rights, any needs that they may have to certain government benefits. Again, it takes assets, financial assets that a special needs or a person with disabilities has, and it protects them so that they still have access to those assets, yet they can still have the benefit of certain government programs. How does this go into place? The individual themselves can put them in place. Sometimes people put things in place before they have a special need just to have it in place, or their need may allow them to still do certain things for themselves. So the individual themselves can put it in place. Parents can do it, grandparents can do it, family members, or friends. Anyone can put into place a special needs provisions for people with disabilities. The only caveat to that is, depending on who puts it in place, is what defines what type of special needs benefit it is. And a lot of times, and you'll probably hear us say this throughout, a lot of times people have the best interest in mind. All they want to do is help. All they want to do is ensure that that individual is going to be taken care of. All they want to do is create some sort of legacy on their behalf. That's fantastic. I encourage people to do that. I think it's wonderful when people do that. However, there are some considerations that have to be taken account for, because if you put your plan in place without looking at all the ins and outs and ups and downs of special needs planning, without being strategic about how you do it, you could be unfortunately eliminating some benefit that that person would otherwise be entitled to. So it's all about the strategy and putting it in place carefully and properly so that they can still have the benefits that they may otherwise get. So most of the time it involves
So,
assisting
Sharon, I'm going to
people.
jump.
Yeah, go ahead. Keith, you gonna jump in there?
No, I was going to say, before we moved on, thank you for the overview. Now, this is great. I wanted to make sure that people understood special needs planning is for everyone at all times, because a lot of times what happens, people plan at point A, and when they pass away or when things happen, might be point B, way in the future, and the circumstances, the condition, the health of at that point in time is far different than that earlier time when they executed the documents. So as we go through this and we start talking about these issues, remember that even if they don't apply to you right now today, that we have to have the flexibility in that estate plan that when it does happen later, and it's usually going to be some situation that catches someone off guard, that we then have that language in place. So this is the one time when people say, I can go online and get something or do it yourself. You probably will never get any language that's going to work properly if you do it. You can make yourself familiar. So please use an attorney for this area at all times.
Yeah, yeah, and Keith and I often say that estate planning
I
as a
apologize for
whole
any
is not
delay. I
one and
think
done.
my internet's a little unstable, so I'm hoping that I'm not frozen at any point in time.
You're not frozen,
Okay,
but you
Shannon?
do sound like a robot. Did you hear me? Yeah, yeah,
I
you
just
aren't
heard it.
frozen,
Yeah,
but you
Mr.
sound like a
Roboto.
robot.
Okay, okay.
That's better.
I can work with that. Okay.
Yeah, well, speaking of being robotic, uh, estate planning is not a one and done thing. It is not a one and done thing. And especially if you are dealing with the special needs considerations that some people have. So Keith has a wonderful thing of telling people to revisit their plan in the decades, those years when their age ends with a zero. I also tell people anytime life events conflict or collide with certain categories, those are also times to revisit your estate plan. So especially if you have considerations involving planning for assisting people with special needs, such as obtaining Social Security benefits or Medicare or Medicaid or any other insurance, or becoming a guardian for someone, which is over their health care, or a conservator, which is over their finances. Anytime any of those things come up, that's an excellent time to not only revisit your special needs planning component, but your estate plan as a whole. And so in that, you should look at what benefits are available to you and the person that you are planning for, if it's not yourself. What services are available, what laws impact what you're trying to do, and laws change all of the time. So that's why Keith is saying, don't let Google be your guide on this. Absolutely consult with an estate planning attorney, a special needs planning attorney who can help drive the ship when it comes to what the laws look like. And then also know what other alternatives there are out there, such as alternatives to a trust. A lot of people do their special needs planning only in a trust, but there are other alternatives and other ways of doing that, like ABLE accounts that are state-run programs. So it includes all of those things. And like Keith was saying, it is not a one and done thing. And it should be revisited as circumstances and situations change, specifically because we know, and you all probably know this as well, people do not make the best decisions in an emergency situation. So planning ahead of time for the possibility of that emergency situation allows you to simply handle the situation itself without all of the strings and added business attached to it. If you've already put these things in place, if you've been strategic about your considerations and your planning. So we said
also,
that.
Shannon, wanted to jump in before we start getting into.
Yeah.
This is an area where a lot of people don't realize that form is incredibly important. And a lot of times, people that aren't lawyers operate by the heart and passion, and they, have conversations, and or they say, I know what they really wanted because I know them so well, but everything in this area is about form and having particular language or not having particular language in something. So this is something where you have to be very technical. So the substance of things sometimes literally takes a backdoor to just having a particular clause in there, or particular form that you need, or trust, a special type of trust in certain situations. So we just want to emphasize this is something that is so rule intensive and is not only federal, it's state. So you're not talking about something like the IRS, and we know how complicated the Internal Revenue Code is, but the Internal Revenue Code is federal. So if you're in California, Chicago, Miami, it doesn't matter. You're all doing the same code. With this area, a lot of the items, some of them are federal, like Medicare, things like Medicaid are state and federal. So each state has variations on how it runs its program. So you have an area that Shannon says not only changing, but it's changing by state. So it could be changing on the federal side, it could be changing on each state side. So it is a maze out there, and if you don't keep up with it, it will cause you a problem.
Yeah. Not only will it cause you a problem, it's probably in most circumstances more of a headache to try to figure it out than people have the time or the energy to sustain. And so again, let somebody who knows the ins and outs of it help you with that. All right, so let's do some definitions. The legal world is full of really big words, right? And it's full of really big words. If you don't understand, you could be doing something completely wrong and completely unintentional. So let's see how the law defines disability. If we looked it up in Webster's dictionary, and it's funny, Keith, I don't even know if people still use Webster's dictionary.
I don't think so.
If we looked it up, if we asked Siri
exactly
how to define disability, it would probably say one thing. But what we have to do is look at how does the law that is applicable to these situations define disability. And it is defined based on whether you are an adult or whether you are a minor. And this all comes under the different codes. So the Social Security Administration administers disabilities, and they define it by saying a disability is the inability to engage in any substantial gainful activity, that's called a SGA, by reason of any medically determinable physical or mental impairment or impairments, plural, which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. Not less than 12 months. So it doesn't have to be permanent, but it can't be something short-term that only lasts for a couple of months. It has to be at least a year.
And we'll make sure we talk about, before we go, that said SSI and SSDI. So sometimes when people hear Social Security, in their mind, they're thinking Social Security retirement. And we're not talking about that benefit that you get when you finish working. That's not that kind of Social Security. We're only talking about Title II, SSDI, Title 16, SSI. So we're going to talk a little bit about what those programs are, but just want to make sure when you hear Social Security in this context, we're not talking about anything with retirement pay.
Right. We're talking about disability. Under Title 16, a child under the age of 18 will be considered disabled if he or she has a medically determinable physical or mental impairment or a combination of impairments that causes marked and severe functional limitations. And so there's an and on the definition for children. And it really was on the other one as well, but it's more emphasized. That can be expected to cause death or have lasted or can be expected to last for a continuous period of not less than 12 months. So it's the same definition for people under the age of 18.
And just to mention, you said that mostly had the same definition with the adult. You had that substantial gainful activity, and we're going to go to the next slide to explain why there's a difference. What does that language mean for substantial gainful activity? It has a critical component that will kind of shock people a little bit when you kind of explain it.
Yeah. Gainful activity, meaning gainful employment.
Right.
So the Social Security Administration defines substantial gainful activity as working and earning income more than a certain amount. All right, working and earning income above a certain amount.
This is critical because since they define disability in context of work,
Go ahead, Keith.
I'm sorry, yeah, I was frozen there, I'm sorry. I was saying we had situations a lot of times where someone in our visual and our interaction with someone, you'll say, okay, well, they're clearly disabled to have a disability. But say, for example, they were an actor and they were, say, they're a blind actor and they got a role in a movie and they got some substantial funds from doing that movie. That's Social Security can be like, well, you're not disabled because you're able to make money. So it's not a matter of just the physical component when you're an adult. It's that ability to make money, which throws things off in a sense because there are many different ways that they can justify you making money. So we just have to get clear. That's why a lot of times people have to battle with the agency for what, when you're looking at them and interacting with them, you would clearly say this, how did you not qualify for benefits? But it's how they're using this language to justify this monetary potential.
Right. And the monetary potential has a cap on it. So for blind individuals, you may have been frozen in saying this, Keith, but we didn't hear you. For blind individuals, that cap is the ability to earn $21.90 or more a month. For non-blind individuals is $13.10 per month. And these monetary figures are monthly, not annual, monthly. That was a great example with the blind individual who gets a role in a show. Now they have sometimes inadvertently taken themselves out of that Social Security benefit that they would otherwise be entitled to because now they make too much. All right. So what are the benefits that people with disabilities are entitled to? There are certain benefits. Some are public benefits that they are entitled to. And that is comprised of only 7 different categories. And we're not going to go into deep detail about some of these, but in a nutshell, they are Social Supplemental Security Income, that's SSI, Medicaid, there's Medicaid waiver programs, and then there's SSDI, which is Social Security Disability Income, and Medicare. Don't confuse Medicaid and the Medicaid waiver forms with Medicare. And then we will talk just slightly, not much, about Section 8, which is federal assisted housing and veterans benefits. So public benefit programs, and Keith, you can
Yeah, this
have
is
explaining this chart.
yeah, this is I try to do this for the visual learners, make it a little easier. So we really want to segregate these into different categories because some of these things are what we call needs based. When we say needs based with any benefit, what we mean is they will require you to have no more than a certain amount of income and also no more than a certain amount of resources, assets. So you have two sets of tests at the same time. So SSI, supplemental security income, that is going to be a needs-based payment. It's a monetary payment, and we'll talk about what it is later. That will lead to Medicaid in most states, and we'll talk about how that works. So most states, once you get SSI, you will automatically get one form of Medicaid, and Medicaid is your health care. So SSI is money, that Medicaid is health care. So going on to the middle category is called entitlement. And when you hear entitlement, sometimes people get offended because there's kind of like a connotation that of a negative connotation of entitlement. What entitlement means in a legal sense is you've done something to have earned it where they can't refuse giving it to you. I can refuse giving you SSI or Medicaid if you worked a certain amount of quarters that's required on your job. Maybe you had you've been working for 10 years, whatever. I can't refuse disability income to you because you worked a certain amount of quarters. To simulate you're not being able to work. So it's more like a substitute wage kind of program as opposed to SSI, which is more just for food and shelter for a lower income group. And then that SSDI is based on your work record. So depending on what you earned and your salary that you've earned will determine that payment. SSI is automatically Medicaid. SSDI is not automatic. You have to wait 2 years. So if you're on SSDI, Social Security Disability Income for 2 years, then you can qualify to be on Medicare. So Medicare is also health care, similarly to Medicaid. What's the difference? Well, Medicare is what people usually associate with health insurance when you get to 65. You worked your whole life, you came out of college, you worked whatever period of time, you get to 65, that's Medicare. Okay? Medicare will pay for certain things, hospital bills, doctor bills, you have a prescription element. But what it doesn't pay for in this context that we're talking about is a lot of times for long-term care. You have certain need to go to a nursing home, or you need someone to come into your house to help you bathe, get out of bed, get out of a chair, cook, take care of yourself, do certain physical things to improve your quality of life. That's not covered by Medicare in many instances. That's why people also need Medicaid. So these programs are really, this set here in these first two columns are which ones cover what, which ones automatically lead to something else. $1 of SSI will lead to Medicaid. We'll talk about some of the details on that. Other benefit programs, Section 8, you may be familiar with that. Someone gets, either they have two types. We have a certain building that you get a place to or they'll free you up to go live out in the community, give you a voucher, and allow you to search for housing. And if that landlord takes that voucher, you can live there, and the government will pay for that portion of the rent. So that's Section 8. Veterans area, it's unbelievable how many veterans benefits are. But when we are talking about veterans benefits, we're usually as elder lawyers talking about what's called veterans pension. So that's a different thing than what people think about with veterans. A lot of times I think about injury. So that's called compensation when, say, someone goes to a conflict, gets hurt, maybe shot, loses an arm or some physical thing. That's VA compensation, gets that disability rating. That's different than what we're talking about a lot of times on this side, which is veterans pension, which is basically a payment to help older veterans. Usually you're talking about people who are 65 or older, so kind of the same age that you would get on Medicare. So once you get to that point where you need help, you have some physical decline, then there's a program with the pension program that will pay you extra money per month to help you afford some health care, either bringing someone into your home or maybe helping you get some assisted living when you move out into a assisted living facility and get some payments. So that's kind of the overview. Needs-based, entitlement, there's no assets on entitlement. All right, needs-based, I said there's income test, asset test, entitlement, there's nothing that stops them from giving it to you. You can be Bill Gates and Warren Buffett and could be on Medicare, okay? Because if you're 65 and you've worked long enough, you get it. So there is no asset income requirement on that entitlement piece. So hopefully that was clear, but we'll get into it a little bit more.
I think it was very clear. Thanks, Keith. So what does SSI provide? That Social Security income provides a monthly grant, it's a cash grant that covers food and shelter for individuals who are disabled, blind, or 65 or older. All right, it is monthly grant that is given to you. This is what Keith was saying about you just have to meet that age threshold and be disabled or blind. And so in 2021, this year, right now, the maximum payment that any individual can get per month is $794. That's the maximum payment that anyone would be entitled to per month, $794.
And that first thing you can think of, you're like, whoa, food and shelter, how am I supposed to live off of that amount? You know, what is that for? And it's not, it's indexed, but obviously it's not indexed for you to live in certain places. So you're not going to find a place in New York City or Buckhead, Atlanta for this, I'm sure. So you realize that it's to serve a certain population of giving you the minimum, but it lacks the ability to make you independent. So we're going to talk a little bit more about how this coordinates with some other things.
So if you have other income that can potentially reduce how much you receive in SSI. Remember I said that $794 is the maximum. So what happens and how is it that everyone doesn't get the maximum? And this chart here explains why everyone doesn't get that. This chart and the next one will explain why everyone doesn't get $794. They don't qualify for that max. And it's because they have certain income that reduces what they would otherwise be entitled to.
So on this one, we have a distinction of unearned and earned. Earned is the simplest one. Wages, self-employment. So basically, if you go out and get a job and you say get a job at some fast food place and you're able to earn your own check, they will say, okay, well, since we were giving you the $794 for food and shelter, since you're making money on your own job, we're going to reduce your benefit. Now, they do it $1 for every $2 you earn after the first 65. So you go through this calculation. So if you made $365 that month, they'll exclude the first 65 and then reduce you $150 because you made $300 over the 65. We're going to take half of that. So that $794 would now go down $150, so down to $644. Okay, so that's how that would work. So they penalize you, but not as sharply as some other things. The unearned income, that's things that you didn't even work for, but you're getting. So if you're getting payments from annuities, pensions, you have gifts from other people, dividends, interest, rents, if you were owning property and had some income payments. So didn't mention this before, but I want you to understand who the population is that might be receiving this. A lot of times you have in people's heads a thought that special needs equates to something like the Special Olympics. So they'll think of, okay, we're talking about someone who from birth may have kind of, cerebral palsy, autism, all these things that come from birth. And that is also, of course, part of this population. But when we say special needs, we're really talking about three groups. We're talking about the young people who have a disability from birth, or a very young age. Talking about the elderly who may be at the point where they're getting older and they need long-term care. But you're also talking about adults anywhere from 18 to 64 who may become disabled at some point in time. So we have a lot of people who have brain injuries, strokes, aneurysms, other things, car accidents, things that happen where you become disabled. So you may have had all these financial instruments that you've owned, right? You may have already owned a stock portfolio, been 45, had a corporate job, have a brain injury. Those pieces of income don't stop coming. So those dividends, interest, things that are going to be counted against you. And unlike the earned income, is dollar for dollar. So if you get $800 of dividends and interest, you lose all of your SSI because that dollar for dollar, that 794 goes down, down, down. And once you get 794, you're zero. So you have to kind of know what type of income you're talking about because there's different effect on that SSI payment.
Yeah. And people sometimes, like for instance, I'm sure Keith has experienced this as well. If you're asking people questions to try to help them, and sometimes they want it to seem better than it really is, right? But that's not the goal. The goal is not to make it seem better than it really is. The goal is to present a very clear picture of exactly what it is, so that you can be entitled to the government benefits that you would be entitled to. You know, don't paint the picture prettier than it really is, thinking you're helping yourself, because you really wouldn't be.
So we have two other
Types of
kinds
income
here.
that reduce your SSI.
So these two are the ones that people won't see coming if you're not in this area. The earned income and unearned, people can kind of get a hold of that. All right, I get a job, earned income, dividends, things. All right, that's unearned. These are creations that are very subtle. I'm going to start with the deemed income first. Deemed income is when someone else in your household, their income is deemed to you. So if you are many times a minor, you may be in school, so you're in special education, you don't have a job. So you're thinking, well, I have zero income, I should get all that 794. Well, they deem income from your parents to you because that's in their mind, that household, they have a legal duty to support you. So they reduce dollar for dollar after the first $20 of deemed income. So that is usually why many kids under 18 can't get SSI, simply because they live at home with their parents and their parents' income is deemed to them. So the other thing, in-kind support and maintenance. We mentioned that SSI is food and shelter. So in the government's mind, if you get a kind of payment that is that actual food or shelter, or something that could be used to do that, that's in their mind replacing what they gave to you, so you don't need their money, so they're going to reduce your benefit. Now, the key thing here is they reduce it dollar for dollar, but they max it out. So they max it out at 1/3 of the benefit. So what does that mean? It means there's a tremendous opportunity for you to help someone in this situation. What do I mean? 794 is their max payment per month. I want to give them an apartment with a rent of $2,000 a month. If I spend $2,000 a month on that rent, it still only reduces their SSI payment up to 1/3. So it's a way to really help them take advantage of this rule. You're not limited to keeping them in this situation where they may have to live at home because other things like earned income and unearned income are going to reduce them to zero. You can spend a lot of money on food and clothing, food and shelter, and still keep their SSI benefit and help them live a better life. So in-kind support and maintenance is absolutely critical to understand that 1/3 maximum allows you a lot of opportunity to help them.
So that's 1/3 on that 794. So that'd be $265.
Right. So you could give them that great apartment, and it still only takes off that 265.
Okay. And then I have another question. The deemed income. Um, that only applies if you're living with someone who has a duty to support you. So parents of minors. Once you become 18, no one's income is deemed to you unless you are perhaps married. Would that be true, Keith?
Yeah. Well, no. Well, right, right. If you're the age piece, once that moment you turn 18, you're an adult, so no deeming to you from a parent. And also, and I know you talked about this another thing, just so people are familiar. Once you turn 18, that's also that triggers that need to get a guardianship conservative of someone because they're an adult. So if their parent is used to doing things for them, we've talked about this in other places. That's also where they have to realize that adulthood is how the law sees them. So they need to trigger that guardianship and conservatorship at that time. So they lose the deeming, but they also become fully adult. So then many times people have to do things formally with the court. But if that person does get married, like you said, now at any age when you're married, your spouse that you live with, they're deemed uh, income to you.
Right, right. And I just want to reiterate what Keith was just saying about guardianship and conservatorship. We had it on here a previous slide, but guardianship is where now you are an adult, you have special disabilities or circumstances in which you cannot speak for yourself financially, you cannot manage your own financial assets, you cannot make your own legal decisions, and in many cases, you cannot speak for yourself medically. At that point, somebody has to petition the court to become your guardian, which is the person who makes your medical decisions for you, or your conservator, which is the person who makes your financial decisions and manages your financial assets. Those are two different yet the same streets, right? If we put a line down the middle of the street, a road, guardianship is on one side, conservatorship is on the other side. Many times they are one and the same person or one and the same people, but not all of the time. Sometimes you can have one person who's managing the assets and the legal decisions and another person who's managing the medical decisions. Also, sometimes someone can still speak for themselves medically, but they can't speak for themselves financially. They can't manage their own assets. So again, especially when people have a minor, somebody under the age of 18 that is a special needs loved one, they have to be on the lookout and know when this person turns 18, I'm not going to be able to do for them like I have been unless I go through the process of becoming their guardian or their conservator. And again, it is not a it's not a disadvantage to them. So many times we we want to help them, and it looks, people think it looks bad. There's a certain stigma associated with it, but not doing what you should do in order to help them creates more issues down the line than putting them in a circumstance where they can get these benefits. This is what Keith was just talking about as far as what is in-kind support and maintenance. How is it defined? Well, the only
And just to
items
take it
that
the
are
next
covered are
last
10.
step, we're talking about this in the context of a.
Go ahead. There are only 10. I'm just going to keep rolling here. It looks like Keith went offline for a moment. There are only 10 categories that in-kind maintenance applies to. That is any food, what you eat, what you drink, how your body contains or gets nourishment. Mortgage payments. This includes any property insurance that the lender may require, or if you live in a homeowners association or anything like that that requires certain insurance, that is included in the in-kind support. Property taxes are included. Rent, like the excellent example that Keith just gave. If you have to pay rent, that is considered in-kind support, and it works in your favor on that. Heating, gas, electricity, water, sewers, plumbing, garbage removal, all of those things are considered in the in-kind donation portion. Keith, you're muted there.
All right. AT&T is being unkind today, so I apologize.
No worries.
I'm trying to start my video, but it's not starting.
No worries.
All right. So
we can hear you. We can hear you much better now.
Okay. Well, that maybe that was the issue. Maybe this is doing too much.
Yeah.
So yeah. So we talked about deeming with the parent and the spouse, and I just wanted to always put this note in here because we have a lot of times where grandparents are raising their grandchildren, and they don't realize that parent in the SSI definition does not include grandparents. So if you are a grandparent taking care of a grandchild, please apply for SSI because you will not have your income deemed to that child, and that's free money that can come in to assist with that household. So I always want to distinguish grandparents are not parents. Step parents would be included, and natural parents, adoptive parents, but not grandparents.
Right, which is why sometimes grandparents will not adopt their grandchildren because that would cancel out that benefit. So what makes somebody eligible for Medicaid? Medicaid, not Medicare, Medicaid. And Medicaid is the one which is income-based. Income-based.
And resource tested. So income and resource. You can get on Medicaid in certain states that are called 1634 states automatically. If you meet the SSI test, once SSI confirms that you have qualified for SSI, they will simply notify the state. You do not have to do any kind of state application. So if I get SSI, they would just tell the state of Georgia, Keith gets Medicaid. I don't have to do anything else. I don't even have to put an application in. When you see the SSI criteria states, those 6 in the middle, they are similar to the 1634 states. The second you get Social Security, a supplemental security income, you automatically qualify for Medicaid, but they just make you go through the hurdle of actually filing an application. So that's all the difference is between the 1634 and SSI criteria state is the SSI criteria state actually makes you go to the Medicaid office and file an application. The 1634 states, you don't have to do any other step. The 209B, they make you have an extra level to qualify above just qualifying for SSI. So you have to kind of know what state you're in because the schemes are a little different. But thankfully in Georgia, I don't know where everyone else is on the call, but if you're in the state of Georgia, you're 1634 state. In most states in the United States, it's 1634 states.
And so this becomes important because even though generally speaking, people are sedentary, but sometimes people move. So for instance, you have a loved one and you want to move them from California because they're too far away and you want to move them to where you are in Ohio. Know that now their benefits are going to change and the eligibility for them is going to change. So knowing things like that, sometimes people take that, or everyone should take it into consideration all of the time, especially when we're thinking about our elder loved ones, that this so oftentimes happens. You know, I'm going to move mom or dad or, you know, cousin or whoever to where I am because it's easier for me to care for them, or I can monitor things a little bit easier. But sometimes that's not the best way to do it because that may take them from one state criteria to another. And if you don't fully examine those ahead of time, you could find yourself missing out on some things. so we're not going to go any more into that. That's what Keith
Yeah, we
just
can go move further. That's what I looked at the time, so we want to make sure we kind of get through a
said.
lot of this. Medicaid is federal, state. Again, Medicaid is health. Uh, Mentioned before, this is a lot of times the long-term care, what they call custodial care. So you will need this more often than not. At some point, I don't remember, the statistics are like 70% of people will need long-term care. So they may be on Medicare because they worked all their life and put their time in. But if you don't have Medicaid, you're going to lack resources to pay for a lot of the long-term care need that you need in your life. Uh, because you have that, and many times with Medicaid, you'll have an asset and income test. That's when that alternative of either the ABLE account, if it's a small amount, you can put in there to qualify, or you might need the special needs trust. So we'll kind of go into that section.
And this is also where strategic estate planning comes into play, because the Medicaid has a look back period on your assets. And so a lot of times people move those assets into a trust. And as long as they do so within 5 years and a day of applying for the Medicaid, then that becomes a non-countable asset for Medicaid purposes. Total assets, when I say non-countable, this is where I was going with this. You cannot have more than $2,000 of assets in order to qualify for Medicaid. SSDI, on the other hand.
This is all work. You basically, you look at your paycheck and you see those amounts going to FICA. This is going towards that. They're recording it to Social Security Administration. Every year, you can get a maximum of 4 credits per year. So as you get 40 work credits, now you've worked 10 years in total terms of time. If you then become disabled, you come out of college, work at 22, maybe 35, you have some kind of brain injury. If you work those 13 years and continuously, you'll have your 40 work credits. Now you can get SSDI. So even though you can't work anymore in that job that you had, you can get that payment. This does not have any asset requirement. And then after 2 years, you can qualify for Medicare. So what happens often in that 2-year period, you have someone using that SSDI, often maybe on some kind of marketplace plan in ACA, or something that maybe they still have COBRA from their last employer or something like that, to hold them over for that time period until they can get over to the Medicare.
Does it matter, Keith, what that 40 credits looks like as far as working? What if you're self-employed? How do they count those credits?
Still, it's based on a dollar, so that 1 credit for each $14.70 of wages. Now, talking about someone like an LLC where they can't pay themselves, technically a W-2, I believe that they just substitute, what you pay in self-employment on your tax return. So they're going to link to that.
Okay.
But it will still be based on that amount of dollars. So what's that, 58, 80, I think, is for those 4 credits. So when you get that amount, you'll get your full credit for the year.
All right. 3 basics of Medicare. You have your Part A, Part B, and Part D. Part A is hospital, Part B is medical insurance, and Part D is prescription drugs. So how do people take all of these different assets and create them outside of Medicare, outside of Medicaid? What do they do? How do they account for and make assets available to a person that has a disability? The main type of way that people do this is through a special needs trust. Again, this is outside of Medicare, outside of Medicaid, outside of SSI, outside of SSDI. We're talking about a special needs trust, and there are certain types of special needs trusts. And if you heard me earlier, I said it's all in the way it is set up so that people can still qualify. So Keith does a fantastic job of putting charts together. So
the thing to remember for anyone is, because they hear that $2,000 limit and they're like, how in the world does anyone qualify that has any kind of uh, been living for a while and accumulated things over time. Because Shannon said these trusts, they have special language in them, and if you draft them a certain way, the agency has said basically, if we see these trusts with this particular language, we will basically turn our eye away from these assets and treat them like they're not yours anymore. So that's really the key. Is you can't just throw something on it that says special needs trust in your word processor and think that you're going to hand it to them and say, okay, well, it says special needs trust and sign it and think that you're going to be okay. You have to have certain language. And the key of them, the first key is who was the source of the funds that made the trust. So is it the person themselves that's trying to get the actual beneficiary, the actual beneficiary with a disability? If so, that's the term they use, first party. Their funds are using this, making this trust. First party is anything where the beneficiary is funding. Third party is, you see there in a source of fund, anyone except the beneficiary. There is no second party. So either you're a first party or you are a third party. Anything with a third party is not limited by family. So it doesn't need to be a family member. It could be anyone in the world. I could be a total stranger and leave someone with a special needs some property. It does not matter as long as it's anyone but the beneficiary. The key distinction is if I am using the beneficiary's fund to source the trust, when things finish, most of the time death, the Medicaid will come back and say, all right, we've kept a running charge of all this money we spent on you, and present it to that trustee and say, hey, this is what we spent. How much money is in the trust? If there's money there, they're going to be paid back. So you see the payback provision. So a lot of times with first party, those D4A, we call them payback trusts. Pooled trust are also paybacks, but it could be potentially in a different way where it stays in a nonprofit agency kind of for helping someone else. But the third party, that's going to basically go, you see, grantor's wishes. If I'm a parent who sets up a trust for my child, when that child passes, because it's my money that created it, when they pass, I get to direct where it goes. So I can say another family member, another child, an organization, I can do whatever I want with it after. I do not have to pay back the state. So that is absolutely critical distinction. So here we talked about, go back one sec real quick. A lot of times we, and Shannon knows this, we make people come into office, they ask for revocable trust because they say, I want a revocable, I want a trust to avoid probate. I don't want to do probate. So those kind of trusts that people set up with when they're trying to avoid probate, a lot of times have the wrong terms in them because usually they're trying to set it up for their children. So they usually say, well, you know, when I pass, I'm going to have my children succeed me as trustee, or I want to make sure they get money when I pass away. So they have provisions in there that might mandate income to the child, or they do the 25, 30, 35, or at the age of 25, give them certain principal, and then at age 30, give them the rest of the principal. So that kind of trust will create problems in a special needs context because the special needs will say, well, if you have the right to get the income or you have the right to get the principal, then we will count it against you. So count against that $2,000 limit. You won't qualify and they'll make you spend it down. So this is really where we have to start educating even the lawyers that do estate planning, not really as their specialty, but try to add it on to their practice because they're doing these trusts with the frame of mind of someone just trying to worry about the income that they get and try to worry about the amount of wealth that they're planning for, and they're not planning for the health aspect.
Yeah, so the part of that is, the important part is ensuring that that beneficiary, that person with the special needs, doesn't have ready access to the funds. They're not the trustee, and there's somebody else that has the discretion to say yes or no, or to withhold any distributions. This is what Keith just said.
Third party back. So that's the most critical thing. But the thing also here, if you have a spouse, and this is a critical thing, many people will set up that revocable trust and say, well, when I pass away, I leave everything to my spouse. Like when I pass away, to my spouse, maybe for life, and then to my children. It's so common because everyone wants to take care of their surviving spouse. But with a spouse that is trying to get on Medicaid, you need to actually have a provision that sends it back from the revocable trust back to their probate estate, because it has to be created as a testamentary trust, passed through the probate process, and the court makes the trust. So if you don't do it that way with that special language and just leave it at the way that it was originally drafted to just pass down to the surviving spouse, those funds won't qualify. So if you have someone who's going through the trouble of maybe they leave their life insurance or their, we talk about Secure Act stuff, they leave their IRA to the trust thinking that their spouse will benefit from it, they can lose all of it because that didn't have that language to send it back to the trust, to the probate estate, to have that trust created specifically by the probate court for their spouse. And it's only for a spouse. You don't have to do that for a child. You don't have to do that for other siblings, parents. Only for your spouse, you have to send it back to the probate. So those first party trusts, a lot of times it's going to happen where you get a big money award and you get a judgment. Now you have this a big amount of money, but you also need health care. So if you keep this $300,000 $1 million judgment and you have a $2,000 limit, there's no way you're going to qualify. So what these first party trusts are designed to do, put those personal injury awards into this trust and then have it held there with that special language. They will supplement whatever they're getting from these benefits, and then once they pass away, that's when the payback will kick in. It also happens, of course, in inheritance. Like I mentioned, inheritance is a big issue. Inheritance can, I want to make a note, can go both ways. If I do proper planning, my inheritance will pass through a third-party trust. If I set it up correctly, it will pass through a third-party trust. They will use those funds while they're alive, and then once they pass, there'll be no payback. If I don't set it up properly, it will go to them directly. Now they have to create a first-party trust because the person who left them the funds didn't send it to them correctly. Now they subjected funds that could have been payback free. Now they're going to require payback. So a lot of these things are preventable if people plan ahead in the family or friends that are leaving gifts, because if you do it wrong, you're really exposing assets that you didn't have to expose.
Right.
These are just the statutory references for those who like to look things up for themselves, but we call them D4As. You talk about ABLE accounts for a little bit.
An ABLE account is not a trust, but it's an account that you set up. It's based on the IRS code, and it allows you to put certain monies in it's kind of like it says right there, like a 529 plan, right? It is administered by the state, and it allows you to set aside funds without them being counted against you. What it's put in place for is to encourage people to save money for themselves or for a loved one, so that they can still get benefits.
And ABLE has this very odd condition to it that makes no sense. When you have this tool that's supposed to benefit this population, they put a restriction on there. You have to be disabled, either receiving SSI or SDI or Medicaid, but you also have to have your disability present before age 26. So if someone is in a car accident or has a stroke and they're 42, they can't even create an ABLE. And it makes no sense because that's the population you're supposedly trying to serve. So why they have this restriction of 25 or younger, because you can't, it has to be present before age 26. So they actually have a act now where they're proposing to raise it from 26 to 46, which still doesn't seem to go far enough. It should go all the way up to 65, but I guess 46 is a step in the right direction. But ABLE accounts many times aren't available because you have this arbitrary low number that your disability had to present itself before. That does not mean you have to create the account before 26. You can create the account when you're 70. But if you say are autistic from a child, we know your disability onset before age 26, so you meet the criteria. So it's just a matter of being able to show that your disability was present before that age.
Yeah, I've thought about what precipitated that age, and I think it probably has a lot to do with the insurance industry, because up until the age of 26, you can be on your parents' insurance, and after that, you get kicked off of parental insurance, whether you're disabled or not. So I think that probably has something to do with it, but that's just my guessing. Really, in all transparency, I'm just guessing.
Yeah, well, I think this has to do with that bias too. Like when people think of special needs, they're thinking of someone in their head who was a special needs child.
Mm-hmm.
And so many of these tools that we're talking about are for adults that have things happen to them later in life. So
Right.
limited to that mindset is causing a lot of people to miss out.
Right. Right. And the one of the main things that I want to point out about the ABLE account is if you have funds in that account, that money does not reduce your SSI if you use it to pay for certain things like food or housing.
Right. And a lot of times what we do when we get study special needs trust is we put in provisions that allow the trustee of a special needs trust to pay some money into an ABLE just for that benefit. So this first one here that you mentioned, Shannon, if I know, or if I pay this rent out of the special needs trust, it's going to lower the SSI. I want to have a provision that says, okay, the trustee can put it into the ABLE account for the same person, and then that person can have the ABLE account pay it, and it's just that mentioned that form. The substance is exactly the same, but the form requires you to use the ABLE instead of the special needs to get that extra bit of money.
Yeah, it's whether you're drawing it from the right hand or the left hand. Right. Key differences, and then we'll be wrapping up here where our time is about to run out. So the key differences to know between a first party trust and a third party trust is third party doesn't have that payback provision.
So do-it-yourselfers, that's number one thing we see is they start grabbing forms off the internet. They say, oh, you have to have this language in here. And they put a payback provision in their revocable trust that they did. And it's like, you didn't have to do that, but if you don't know this area, people start reaching for clauses just to, in their mind, protect themselves. And they may be causing a loss of money.
Right.
Or vice versa, where they take something that's a third-party language, not realizing the difference, and they leave out that payback language, and then the person gets that inheritance and then doesn't qualify. And once you put that application in for Medicaid, you can't take it back. So if they see that trust there, and those funds are available, there's no oops, you can't take it back. So
right,
you want to get it right.
No do-overs on that.
No do-overs. Yeah, it's not the kids tag. No do-overs.
Right. First party special needs trusts do have that payback, as well as the pool trusts.
Right. And I've highlighted all on that, and that's another place where people get stuck is you can't put just your state. So they'll draft something there in Georgia and say, I promise to pay back the state of Georgia, and then the state of Georgia will reject it and say this is accountable trust. And it's what are you talking about? I said I'll pay Georgia back. And they said, no, you have to pay all states back. So that language has to say, because like you said earlier, people move. So if you put language in there that just says Georgia and then you move that person to Maryland, then your trust doesn't have that language that Maryland's protected, so they reject the trust. So that you have to say Georgia and any other state where you receive care, or just all states in the United States. So that subtle difference has literally gone to court where people have lost benefits because they had that individual state listed rather than all. Yeah, this first part, the sole benefit, we had this situation a lot of times where someone wants to treat the trust like the family trust. So they get that big, $1 million judgment. All of a sudden now everybody wants the trust to buy cars and buy a house for the entire family, and the trust pay all the expenses each month and all that. They said, no, you got to pay your pro rata share. If you want to give Johnny an apartment with his brothers and it's $3,000 a month and there's two brothers, then Johnny's trust can pay $1,000. But Johnny's trust is not going to pay $3,000 and everyone live well off of Johnny's trust, right? So that sole benefit is that kind of thinking. We don't mind you making his life better, but you're not making the whole family's life better.
Right. And then contrast that with a third party supplemental trust. That one can be used for multiple beneficiaries. For instance, say there's a family that has more than one special needs person in the trust. Do you have to set up a separate, or in the family, do you have to set up a separate trust for each of them?
Oh, for the third party, no.
No, you can have more than, they can benefit multiple beneficiaries.
Right.
Even if they are multiple beneficiaries with special needs.
Right. Special needs trust must be irrevocable. A third party can be either that regular revocable that we talk about people make all the time, or it could be a special irrevocable trust. So you have the option when someone else is making a trust, whether it's revocable or irrevocable. So that gives them incentive. You can create it now, but if, God forbid, that beneficiary passes away before you do, you have the ability to revoke that trust and leave it to someone else. So that option of making it revocable for a third-party grantor is really important. And first-party special needs trust, since the person is making it themselves, is only created during their lifetime. Okay. But with a third-party special needs trust, since I'm the grantor, I can create it while I'm alive. I can create a special needs standalone trust, or I can do my revocable trust that I normally would do with special provisions in it that will create the special needs trust at my death. So I can do it under my will and have my will create that special needs trust, or I can have the revocable trust I made when I die, have a sub-trust underneath it. That's the special needs trust for that person.
And that way that all of those assets pass outside of probate.
Right.
All right. Again, before we wrap up, I do again want to thank ICABA for providing this platform. Getting the information out is key. We often know that people do better when they know better. And the only way people can know better in order to do better is to be educated on it. So like I said in the beginning, it is always my pleasure, my honor, as well as Keith's, to present this information to the public, to the members of ICABA, so that we can know better and do better. Any questions on special needs? Any questions? I don't think anyone is muted.
I don't see any questions.
If there are no questions, thank you all for joining us this evening. Again, my name is Shannon Wilson. I am the founding attorney of Legacy Legal, and then Keith Miles, who is a phenomenal Georgia elder law attorney, both of us here in the Metro Atlanta area. If you have any questions, feel free to reach out to one or both of us. We'd be delighted to help you, assist you with your estate planning needs here in the Georgia area. Again, thank you all for joining us this evening. Also go to ICABA World Community, check out the organization, entertain the possibility of membership within the organization, and especially go to the estate planning mastermind group where you can get more information. You can also see the recordings from our previous Wednesday evening workshops.
And thank you, Shannon, just for being wonderful. All this time, this is our 10th one, and it's just been an amazing time. So I know we're gonna have a little summer break, but just want to let you know I appreciate you, and you've been.
Yeah, I did too, Keith. It's been great. I'm gonna miss you this summer, but yeah. we'll get it going again in the fall.
Yes, ma'am. All right. So
thanks, everyone.
Hey.